So I think we're going to move on to our form. We're going with, my favorite, Streamlined Domestic Offshore Procedure. No, Streamlined, yes, we're now Domestic Offshore.
Domestic offshore.
Okay, so domestic offshore isn't quite as good as offshore, foreign offshore.
Foreign offshore.
Foreign offshore, you have no penalty.
Right.
With the domestic offshore, you have a penalty. And so this is where the form takes a little bit longer because there's calculations to do.
Right.
So generally, though, we have this entire first slide is basically a repetition of what we just went over with Michelle. So I don't think we need to do that. But basically, the same issues exist. But I think if we can move to the next slide, Chris, and then we'll talk about the things that exist on Form 14654 that aren't on the foreign offshore procedure form, and that's basically our penalty computations.
Right.
Okay.
So the first one is this need for expanding rows. So right now, when you have to calculate the interest and penalties for a streamlined domestic, you've got to list all the different accounts for each in particular year so the IRS can kind of see what the numbers are for each particular year. The problem is, like we mentioned before, some of our clients have more than 4 accounts, which is the number that you can currently put in on the form. So how we get around that, we always have to put see attached, and then we have to include our own usually lengthy Excel spreadsheets or other rundowns of the client's accounts. It would be much cleaner, I think, if the IRS would just allow for these expandable rows. Which is already a capability in these forms because they give you an expandable area to write the narratives that we just talked about a minute ago. So if we could just get an expanding amount of rows, it would allow less paperwork, it'd be less things for the IRS to lose. It's all in one form, one central place that the IRS could get this information. And it would just really cut down probably on just processing time. It would just make it cleaner, make it better, just be better overall. The next thing is about the penalty computation itself. So you are allowed in your penalty computation to exclude foreign assets in which you don't have any direct financial interest and you don't own directly. So usually accounts that
something your father's and your father put the name on something.
Exactly.
Right? Okay.
If you're on there as a signatory authority, a power of attorney type, or if there's funds in your account that really aren't yours.
So a joint account that maybe your dad's taking all the money to, or your mom, or it's back in the home country, you're on the account, but it's his account.
Exactly. It's his dollars in the account. Your names happen to be on it. So for the FBARs, sure, you got to report it as is, but for the penalty computation, it's not quite right to penalize you on money, on dollars that aren't really yours. Now, in the form itself, there's no real good explanation of that. There's something that's additional digging that a client would have to do to figure that out. If we had some clearer direction on the form or give you a place where you could list what's included and what's not included, that would reduce questions needed to be asked by the IRS. It would reduce confusion by the taxpayers. So if they are having to handle this by themselves, they can do it correctly the first time, and then you wouldn't have as much back and forth.
Well, right, you could result in someone paying too much penalty. I mean, way too much penalty, something that's just not completely right. And then that person, well, I paid too much penalty, and then they're telling their friend about the program, like, I don't know if you should do it because I had to pay a penalty. And then the friend saying, well, are you sure? Oh, yeah, no, I paid it, they took it. And so you're de-selling people on going through the program that you want them to go through. And so
the program that most people should be going through in this situation, in this type of situation. The next one would be for assets that shouldn't be in the penalty base, right? So did we touch on this already a little bit?
I think that was in the offshore. We talked about how there's penalties based that are not reported on FBAR, and now in the streamlined, if foreign real estate doesn't go in your penalty base at all, it's based strictly on your accounts.
Yes. So for the full OVDP, you have to include your real estate, and that can really be a burden for some people. Streamline doesn't have that, so there's no good place to indicate what's going in and what's coming out, what you have that's outside that's not included in the penalty base. So that'd be nice if we had a spot that the clients could identify something like that, so they could identify taxpayer mistakes and really get to the root of an actual problem instead of just kind of groping in the dark.
Right. So it's something like, yes, we know full well about this account. Here's a specific reason why we're not going to include it, because I know you're going to have the question. We know you're going to question why we aren't putting a penalty on that. Mm. And now I think that's it for Form 14654. And our next slide. So there is one more form that the IRS has looked for suggestion on, and this can be found nowhere on the internet. The Streamlined Domestic Offshore Procedures Form 14708. Can you tell me a little bit about that, Michelle Wynn?
Really what this form is to request that the IRS reconsider your penalty amount. If you had originally gone through the Streamlined Domestic Offshore Procedures and you included a Canadian registered retirement plan in your penalty computation, since the Streamlined program started, the IRS has since clarified that the Canadian registered retirement plans were not intended to be included in the penalty computation. So if you made your submission before they issued that clarification, you can submit this form to have your penalty reduced and have the overpaid amount refunded back to you.
So originally the IRS was seeking penalties on RRSPs. They have now said you don't, or there was unclear.
It was unclear.
Okay.
The suggestion was there that they weren't intending to penalize those, but only if you knew the details of the OVDP program.
Okay, so now you can get that money back if you did happen to pay.
Correct.
Okay, well, that's a good thing. But there are some suggestions on the form that you would like to see be done. And why don't you give us a rundown of those?
Well, currently with this form, if you're submitting it, there's nowhere to indicate if you have a representative preparing the form or just a representative in general who should be contacted about it.
Very common that we've been seeing that throughout.
Taxpayers are often quite concerned about being contacted directly by the IRS when they have representatives, so listing on the form who you want to be contacted about the form is important. Also, this form is unique in that it is asking the taxpayer to list their email address, presumably so that an IRS agent reviewing the form can email them with any questions. I'm very supportive of more email correspondence, however, not directly with taxpayers, because the IRS openly advertises that it will never email you. So then asking for the taxpayer's email address, either one is asking for information that will never be used, or two, and the worst possible alternative is that the taxpayer follows every press release the IRS has ever given. They get an email from a revenue agent or someone working in the Streamlined program who emails them to ask them a concrete question, and they say, but the IRS said it would never email me, and just moves the email to spam. Now they're not responding to questions the IRS is posing because they didn't believe it was the IRS.
And so maybe this refund that they're entitled to never gets processed. The statute of limitations to get the money back before they finally realize what happened, that their form wasn't submitted because the revenue agent emailed them, which they properly ignored.
Or is expecting an email from the revenue agent now because this form asks for their email address. So when they get a spam email that's saying it's from the IRS, they believe it.
And then do something worse.
And then they start giving their information to the phishing scams.
Yeah. So that could be really, really bad. Wow.
Overall, bad question.
Yeah.
Ask for a representative's email address, but not a taxpayer's.
Yeah.
Just the same program that we had with the Streamlined Domestic Offshore Procedure Forms.
Their FBAR
it's asking you to keep information for 6 years from the date of this penalty reconsideration, which is taking it even farther outside the statutory period that the IRS is allowed to demand that you retain records. So try to correlate the requirements with the forms with the requirements in the law.
Excellent suggestion.
The IRS has not yet created any estimate of the amount of time it will take people to fill out this form, so I'm not going to criticize
2 hours. 2 hours.
It will take everybody 2 hours to learn about the form and fill it out. And the draft version I'm not sure if this is something they're planning on fixing when they finalize the form, but currently you can't save information electronically. We raised the issue with that with regards to the penalty computation form and OVDP. It is very important when you're having these forms getting completed that people can save it in electronic format so that they can review it and edit and make sure it's correct and not have to retype the information every single time they do it, because that's just going to lead to typos and errors that could be very costly for the taxpayer or the IRS.
All right. Well, thank you. Well, I think that wraps up our suggestions to the form. Chris, if you just move to the last slide, and now we'll just get to the point of this, where a lot of we do offer these webinars to people and help them out, and people get the idea that maybe we do know what we're talking about, and so people are looking for assistance. And if so, you can email us at info@irsmedic.com. or call our toll-free number, 888-477-4258. We also have phone numbers in Hong Kong and Switzerland to call for those abroad. But a common question we're asked, people read these, is, hey, could you just do my certification for me? And it's a question that we do not like to be asked because our answer is always no. And I think if there's one thing that we've learned from, as we're listening through this and our various people that we've had today, we're putting our names on everything we sign, even where the IRS doesn't ask us to do it. We actually put our names on. So we're the ones certifying everything. And if there's a problem with anything, we're on the hook. So what we do is we'll do a case start to finish, or we'll take over a case that's going badly. But one thing we won't do is a a la carte certification. We're on the hook for the entire return. We're on the hook for everything. So that's just one thing to be aware of. We do offer webinars where we're always looking to give out information and help people make some sense out of that. So that would be where we would advise people to go if they weren't interested in hiring us full service.